I'm George Whipple. This is Employment Law This Week, and here's what you need to know. After a long, drawn-out saga, the D.C. District Court has granted the EEOC's request to end the collection of 2017 and 2018 Component 2 pay data. The Commission has signaled clearly that it will not collect Component 2 information for 2019. This puts an end to the federal government's collection of pay data, at least for now. But more and more companies are conducting their own pay equity audits. They're viewing these audits as a necessary business practice to address potentially discriminatory pay disparities and manage litigation risk under the many recently broadened state equal pay laws. It's important to note that the collection of Component 1 demographic data is not impacted by the battle over Component 2. The government traditionally set a fall deadline for these numbers, but the Obama administration moved it to the spring, beginning in 2017. This year's deadline has not yet been set, but employers that are required to report should be preparing that Component 1 data now. The CDC has released new guidance that provides clarity on how employers should respond to the coronavirus outbreak. The agency recommends that employers actively encourage any sick employees to stay home. If an employee is diagnosed with the coronavirus, the guidance states that employers should inform the workplace of possible exposure, but maintain confidentiality as required by the ADA. The guidance also outlines what employers should do if the outbreak spreads to the United States. OSHA and Cal-OSHA also recently released similar guidance. Two controversial new labor laws in California are facing major challenges. In January, a district judge issued a preliminary injunction against Worker Classification Bill AB 5 that exempts the trucking industry. As it stands now, the law would make it extremely difficult to classify workers as independent contractors. There are at least 8 bills in the state legislature aimed at narrowing it. Another 2019 law was recently stopped by a federal injunction. AB 51, which prohibits employers from requiring applicants and employees to sign arbitration agreements. While the injunction is preliminary, the order makes clear that the court is inclined to find that the law is preempted by the Federal Arbitration Act. Finally, a reminder that 14 states will go to the polls on March 3rd, Super Tuesday. Check the laws governing time off to vote and posting obligations in your jurisdiction to make sure you stay compliant. And that's what you need to know this week. Thanks for watching. We'll see you next time.